Running out of time now. All right, good evening, folks. I'm going to be presenting Texas v. Johnson, 1989. The facts are, in the summer of 1984, the Republican Party held its national convention in Dallas, Texas, to support the Reagan re-election campaign. During the convention, a group of about 100 protesters participated in a march through the city to protest the Reagan administration's policies. During the march, one of the protesters removed an American flag that was hanging off the front of a bank building. They handed the flag to Gregory Johnson, who was one of the organizers of the march. As the march came to an end, Johnson took the flag and doused it with kerosene and lit it on fire. As the protesters watched the flag burn, they chanted various anti-Reagan songs, including "America, the red, white, and blue, we spit on you." The police proceeded to arrest Johnson, and they charged him with violating the Texas flag, a venerated object desecration law. He was convicted to serve 1 year in prison and to pay a $2,000 fine. He appealed to the state court of appeals, and they affirmed the decision. Then he appealed to the Texas Court of Criminal Appeals, in which they reversed the holding. Texas then filed for certiorari to the Supreme Court, and so it landed in the Supreme Court. The legal question here is the desecration of the American flag by burning or otherwise a form of speech that is protected under the First Amendment? The arguments in the case were from the petitioner, the state of Texas, are the First Amendment is not absolute, and expressive conduct demands less constitutional protection than pure speech. The Texas flag desecration statute advances two substantial interests, and this is important here. Number one being protection of the flag as an important symbol of nationhood and unity. And number two, the prevention of a breach of the peace. And the third argument for Texas is the Texas law is a valid time, place, and manner restriction on demonstrations. For the respondent, Gregory Lee Johnson, the arguments are the Texas statute is a viewpoint-based restriction on political expression because the state seeks to protect one view, that is, the flag is a symbol of the nationhood and national unity. Number two, because the state law singles out conduct that will seriously offend one or more persons, the statute violates the First Amendment prohibition on content-based discrimination. And the third, Johnson peacefully burned the flag in an obvious act of political expression that merits First Amendment protection. In a 5-4 decision, which is not a super strong decision, but the court held that Johnson's burning of the American flag was protected expression under the First Amendment. They found that his actions fell into the category of expressive conduct and had a distinctive political nature. The court found that you cannot justify prohibiting speech just because people take offense to certain ideas or expressions. Brennan said, and I quote, "If there's a bedrock of principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable." In this regard, the court held that the state officials did not have the authority to designate symbols to be used to communicate only limited sets of messages. So Justice Brennan suggested that courts should, when deciding the case, suggested that the court should consider whether Johnson intended to convey a specific message, through his conduct and whether it was likely that the audience would recognize the message. Brennan used this as a determination of the line between mere action and communication. Because the demonstration coincided with the Republican National Convention and the accompanying political chants clarified the message, Brennan felt that both elements were satisfied. Johnson could only be punished if the state could show that it had a compelling, content-neutral reason for suppressing his acts. Brennan found that there was no imminent threat of a breach of peace that resulted from the burning the flag. He also rejected the bad tendency test from prior jurisprudence. The state was unable to propose any other related compelling interest. Brennan says, and I quote, "Hence we have recognized the expressive nature of students wearing of black armbands to protect American military involvement in Vietnam." That's from Tinker versus Des Moines Independent Community School District of 1969. Of a sit-in by blacks in a white-only area to protest segregation. That's from Brown v. Louisiana in 1966. Brennan says that it is especially pertinent to this case are our decisions recognizing the communicated nature of conduct relating to flags, i.e. attaching a peace sign to the flag from Spence v. Washington in 1974, refusing to salute the flag. That's from West Virginia Board of Education v. Barnett in 1943, and displaying your red flag, and that's from Stromberg v. California, 1931. We have held that all may find shelter under all of these cases I just mentioned, may find shelter under the First Amendment. He says, we have not automatically concluded, however, that any action taken with respect to our flag is expressive. Instead, in characterizing such action for First Amendment purposes, we have considered the context in which it occurred. He says, Johnson's burning the flag was conduct sufficiently imbued with elements of communication to implicate the First Amendment. So the O'Brien test is applied here in this case. And in order to apply the O'Brien test, the court must decide whether Texas has asserted an interest in support of Johnson's conviction that is unrelated to the suppression of expression. The state's two interests to justify conviction are number one, preventing breaches of the peace, and two, preserving the flag as a symbol of nationhood and national unity. The court holds that the first interest is not implicated on this reason, and the second is related to the suppression of expression. Texas claimed the conviction was justified for preventing breaches of peace. However, no disturbance of peace actually or threatened to occur. The state claimed the state claimed an audience that takes serious offense to the expression amounts to burning a flag is necessarily likely to disturb the peace. The court recognizes, on the contrary, though, that a principal function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction, and even stirs people to anger. So the court further dismisses the possibility of fighting words that are likely to provoke, quote, likely to provoke the average person to retaliation, because no reasonable onlooker would have regarded Johnson's generalized dissatisfaction with the policies of the federal government as a direct personal insult or an invitation to exchange fisticuffs. Brennan says here, the First Amendment does not guarantee that other concepts virtually sacred to our nation as a whole, such as the principle that discrimination on the basis of race is odious and destructive, will go unquestioned in the marketplace of ideas. We decline, therefore, to create for the flag an exception to the joust of principles protected by the First Amendment. The way to preserve the flag's special role is not to punish those who feel differently about these matters, is to persuade them that they are wrong. And so I talked about the O'Brien test. So what they did is they kind of refined the O'Brien test, and they wanted to find out, does the regulation further a compelling state interest? Here you go. I'm sorry. If the action is expressive, is the state's regulation related to that expression? And if no, it's a intermediate scrutiny. But if yes, then it's strict scrutiny. The state's action, if the state's action is related to the message, then the court has to apply strict scrutiny. The purpose is to promote so the court found that the state's purpose for that statute was to promote national unity, and they found it to not be a compelling state interest, not neutral in regard to that viewpoint. So they applied the strict scrutiny prong of the O'Brien test. This is related to O'Brien because both cases are about expressive conduct relating to burning something in symbolic protest. However, the differences between the two is that in O'Brien, it was a draft card that he burned, and in Johnson, it's a flag. So the differences there is that a draft card has a practical purpose, whereas a flag is specifically only an expressive object, and that's its only purpose. So I have a question. Well, before I get to my question, I'm going to circle back to the importance of the dissent and the concurrence. So Kennedy concurred the majority of Britain's majority writing, saying that sometimes we have to make decisions we don't like because they are the right decisions. And in this case, this is one of those right decisions. It's in this rare case. And for the dissent, Chief Justice Rehnquist, he says that in holding the Texas statute unconstitutional, the court ignores Justice Holmes' familiar aphorism that a page in history is worth a volume of logic. That's from New York Trust Co. versus Eisner, 1921. He says, for more than 200 years, the American flag has occupied a unique position as a symbol of our nation, a uniqueness that justifies a governmental prohibition against flag burning. He calls the American flag the visible symbol embodying our nation. And Johnson participated in several expressive conducts that day, including marching and various chants. But he could have burned the flag in private. Now, I guess my rebuttal to that is that, you know, what good is it burning a flag in private if you're conducting an act, an expressive act, and nobody can see what you're doing? So I don't really agree with that part of Chief Justice Rehnquist's dissent. In Justice Stevens' dissent, he writes, he calls the flag a unique symbol, not just another host of symbols like state flags or armbands or like privately promoted emblems of political or commercial identity that are not necessarily controlling. It's a value that cannot be measured. He compares the burning to allowing like graffiti on the Washington Monument as expressive conduct, which we all know that that would never be allowed to happen, at least I think. And so, pardon me while I pull my notes back together. I guess I'm wrapping this up, and I'm just going to say that like what I don't agree about the case is the decision is, you know, the friend of his or the fellow protester took the flag off of a bank, the front of a bank. So he basically stole private property and burned it. So I'm not sure why Johnson was not like tried for destruction of property. And some 32 years later, we could actually point to a case last year that in Washington, the leader of the Proud Boys basically did the same thing. Somebody pulled a banner off, a BLM, a Black Lives Matter banner off of a church. And then the leader of the Proud Boys burned that, and he got 5 months in prison for doing that, for destruction of property. So I see those two things kind of coinciding, although not that I agree with the Proud Boys message or anything, but I do think that there's a little bit of a double standard there. But of course, this is the future, and that happened 32 some odd years later than Texas v. Johnson. So I guess that is it. I don't think I have anything else left to say. Yeah, I think that's it. What I'm going to do is screen share to show you my works cited page, and then I'll end the video that I have like 9 minutes. All right, there is my works cited page. Thank you for listening to my case brief, and good luck, everybody. Let me stop screen share. This is always so awkward. All right, thank you.